5 seconds to go. Start. Hence, the learned judge held that neither Article 142 nor Article 144 had any application. Stop. The learned judge also held that though the suit had been instituted in 1961, it was amended after 33 years in 1995, to seek possession and to bring it within the purview of Articles 142 and 144. Stop. On these grounds, the suit was held to be barred by limitation. Stop. Para. Justice S.U. Khan held to the contrary and was of the view that suit 4 was within limitation. Stop. The learned judge indicated 5 reasons for holding that suits 3, 4, and 5 were not barred by limitation, which have already been adverted to earlier. Stop. Para. Thus, by a majority, Justice Sudhir Agarwal and Justice D.V. Sharma, the suit was held to be barred by limitation, Justice S.U. Khan holding a contrary view on this issue. Stop. Para. During the course of the arguments before this court, Mr. K. Parasaran, learned senior counsel appearing on behalf of the plaintiffs in suit 5, submitted that suit 4 would be governed by Article 120 of the Limitation Act alone, and that neither Articles 142 nor 144 would apply. Stop. This submission is sought to be supported on the basis of the following propositions. Para. The primary relief which has been sought in suit 4, prayer A, is a declaration that the property in dispute is a public mosque, and hence, the suit does not seek a declaration for the enforcement of the right of worship, para. When a suit is filed for a declaration of title to property, which is attached under section 145, it is not necessary to seek further relief for the delivery of possession, since the defendant is not in possession and is not in a position to deliver possession. Stop. The property under attachment being custodial legis, the receiver is bound to hand over possession to whoever is held to be entitled as a result of the civil adjudication, para. A prayer seeking possession was not necessary, since the property was custodial legis since December 1949, and the prayer was introduced only to circumvent the period of limitation of 6 years imposed by Article 120, para. Status of limitation are statutes of repose, para. The period of 6 years under Article 120 has to be computed from the date when the right to sue accrues, and there is no right to sue unless there is an accrual of the right asserted in the suit and an infringement or a clear and unequivocal intention to infringe the right, para. The cause of action as pleaded in paragraph 23 of the plaint is stated to have arisen on 23rd December 1949, when the Hindus unlawfully entered the mosque and desecrated it by placing idols inside, thus causing an interference in the offering of prayers by Muslims, para. The case of the plaintiffs is that the injury which was sustained was of a continuing nature and not the wrong, which was complete on the date of the desecration. Stop. The bar of limitation is sought to be overcome by alleging that the cause of action is renewed by virtue of a continuing wrong. Stop.